Welcome back, dear participants, to the second video of the first module. In this part, I will enter directly into our topic, transboundary aquifers in international water law. I will start by introducing you to some of the challenges we face for the management of transboundary aquifers and building cooperation on these transboundary aquifers. And then I will give you an overview of the general principles of international water law. I will base my analysis on the draft articles on the law of transboundary aquifers, since it is the only instrument, the only global instrument completely tailored for the specific characteristics of transboundary aquifers. And in the following videos, I will go through the specific principles deriving from this draft article to the miscellaneous provisions, and I will give you words of conclusions. The rest of the lecture will be devoted to the arrangements on transboundary aquifers and the focus on your region of interest. So what the challenges do we face? First, we face challenges that are common to the management of all groundwater, whether it is transboundary or not. Groundwater is an invisible resource. It is out of sight, out of mind, and to manage it, we need to know it better. It is difficult, you can imagine, to manage what you don't know. Hence, the importance of knowledge is very important for groundwater, for the management of groundwater. So to improve the knowledge, we need data and information on specific characteristics such as the availability of the resource. We need to know how much water there is in the aquifer, for example, what is the status of this water, and what different uses rely on this resource. We need for an aquifer to consider the geological formation, because an aquifer will not react the same thing depending on the geology. A karstic aquifer reacts very differently than another type of aquifer, for example. When we also consider groundwater or aquifers, we need to assess the impact of human activities, because as I mentioned to you in the introduction, for example, the draft articles, they apply to other uses than the use of the aquifer and the groundwater, because activities such as what you can see here, agriculture, can impact the and pollute the water underground because of the use of chemicals which can infiltrate. Depending on the nature of the soil, the infiltration can be fast or slower, but at the end it will impact the quality of the groundwater. Same for illegal dumping, which can infiltrate some products. Some polluting products can infiltrate from these wastes that are just illegally dumped like this on the floor and on the soil. And for example, any discharge of non-treated wastewater or other will also affect the groundwater. That was, for example, treatment plants, as you can see here for the municipal sewage, is very important. The water released will reach a level of quality acceptable for release in the nature. That's why all these activities need to be regulated and controlled. There is a need to control land use. That's why also the management of groundwater goes beyond the management of water only. And the last challenge, and this challenge is specific to transboundary aquifers, is the borders. The borders add an additional challenge, because in each side of the border, the regulations are different, the management is different, the methodologies used to collect data are different, the uses are also different, and there is the need also to have a full knowledge of the aquifer. So it creates the need to exchange the data or to cooperate on improving the knowledge, etc. This is the most difficult challenge that we will face for transboundary aquifers. This is just a reminder about international water law instruments. So our two conventions binding for their parties, and also including principles of customary international law and the draft articles on the law of transboundary aquifers. These three instruments share common principles. As I said, the focus in this model will be on the draft articles, as they were specifically tailored to the characteristics of transboundary aquifers. Under general principles, I will present to you the core principles of international water law, which are considered also as part of customary international water law, the equitable and reasonable use and the no harm rule, and also the general obligation to cooperate and its corollary, the regular exchange of data. In the following video, I will present to you the specific principles. So the first principle, the equitable and reasonable use. This principle can be divided into three parts. The first part is the equitable utilization. According to the draft articles, aquifer states shall utilize transboundary aquifers or aquifer systems in a manner that is consistent with the equitable and reasonable accrual of benefits therefrom. This means that all the states have the same right to use, they have equality of rights, but they have an equitable allocation, not an equal allocation, an equitable allocation of benefits among the states sharing the aquifer. On the reasonable utilization, aquifer states shall aim at maximizing the long-term benefits derived from the use of water contained therein. This provision includes the idea or the concept of optimal use, and it is also important in the case of non-recharging aquifers, where the idea is to making the best within the longest period possible. In the case of non-recharging aquifer, as the name says, the aquifers do not receive a recharge. So whatever water you are using will not come back. It's a mining development, mining exploitation. And the idea of managing these aquifer, of using the water from this aquifer, is to have an optimal use, meaning that the idea is to keep the availability of the aquifers for the longest period possible. This is what it says here when it says maximizing the long-term benefits. If you use immediately and you, let's say, waste the water, you will have a shorter period of use of the aquifer, which can impact the development of your country. Whereas during a long period, states might have the opportunity to develop economically and have the possibility to start relying on alternate water resources, non-conventional water resources, for example. The provision continues by saying that they, meaning the aquifer states, shall establish individually or jointly a comprehensive utilization plan taking into account present and future needs of and alternative water sources for the aquifer states. So the comprehensive utilization plan is the tool for realizing the maximization of the long-term benefits. By following this plan, the states will use, hopefully, the aquifer during a long period. And it will be a planning, like it is called, for all the activities that rely on the aquifers and how to use this aquifer in the most optimal and efficient way. The provision considers the present and future needs. This reflects on the concerns of sustainability and intergeneration equity, which are already found in paragraph 7 of the preamble of the draft articles. And the provision also already includes element of cooperation, because it speaks us about jointly. So the states can establish this plan in an individual way, but also, and this is, let's say, This is better in the case of cooperation. Jointly, it would be a joint plan for the states sharing the aquifer. But the equitable and reasonable utilization principle so includes rights for the aquifer states, but also it includes a duty and obligation. The states have the duty to protect the transboundary aquifers, and they shall not utilize a recharging transboundary aquifer or aquifer system at a level that would prevent continuous of its effective functioning. This refers to the cases of overuse, overpumping, overdeveloping water from the aquifer, which can affect its functioning. So the states have the obligation of maintaining this functioning, and this includes also control on the utilization level. So the issue is also the protection of the quantity of water. The second, the core principle of international water law is the obligation not to cause significant harm. This obligation is an obligation of conduct, not an obligation of result. It is an obligation of due diligence, like we say in legal terms. So it means that the harm is not caused intentionally or by neglect. Let's say it happened by accident. The harm happened through the use of the transboundary aquifers or through other activities that have or are likely to have an impact upon the transboundary aquifer. For example, it could be an accidental case of pollution that will affect the transboundary aquifer. And this obligation applies to the aquifer state, but also to the discharge zone state. And the harm caused has to be significant. Now, there is no one definition of significant. This is determined on a case-by-case basis, because significant is a flexible and relative concept. It means that what is significant in one case might not be in another case. It is based on factual considerations, so the specific circumstances in the concerned transboundary aquifers, and what is considered is also the quantity and the quality. It could be a harm that affects, for example, the quantity of the water, and it can be a significant. It's not only a matter of quality of water. The general obligation to cooperate is the general obligation under international law, not only for international water law. It is based on sovereign equality, territorial integrity, sustainable development, mutual benefit, and good faith. And under this obligation, the states are required to reach equitable and reasonable utilization and appropriate protection for the transboundary aquifers. The obligation to cooperate can be practiced through the establishment of joint mechanisms of cooperation. Of course, when a cooperation is established, it's always, let's say, better to have a form of institution, a joint mechanism which can put in place this cooperation and what has been planned under this cooperation. So in this last slide of this video, I will present to you the last general principle. It is the principle of the regular exchange of data. It represents the first application of the general obligation to cooperate. The first step under this principle is to exchange data on a regular basis, and also to exchange the readily available data and information, meaning you exchange what you already have. At this stage, there is no request to provide additional data. But this request appears in the second step, where states are requested to provide their best efforts to collect data to improve the knowledge about the transboundary aquifer. I presented to you under the challenges that what is important is always to improve the knowledge. So in this case, not only in this case, in many cases, there might be the need to collect different data and additional data to what is already collected. So states can do this effort of collecting new data or another sort of data. They can do this effort either individually or jointly. Some states, when they establish cooperation, they establish a joint monitoring network. And also this can be done through the support and with the assistance of an international organization. IO here meaning international organization. And the third step concerns that the request that can come from one of the aquifer states to the other aquifer states sharing to the aquifers, to other states sharing the aquifer. The request is to provide data not readily available, and this state might be requested to pay for this additional data, because you know that collecting data can be costly and some states do not necessarily have the means. So this request can be subject to payment. Not necessarily, but can be subject to payment. And under these three steps, there is a transversal obligation. The data should be exchanged in a manner that facilitates its utilization by the other aquifer states. Each state of the aquifer might have a different methodology. They might afterwards, when they establish the cooperation, harmonize this methodology, but at the first stages it is often not the case. So they should not only exchange the data, but also exchange the methodology, the process, to facilitate its use by the other aquifer states. So this is the last slide on the general principles. In the following video, we will enter into the more specific principles to transboundary aquifers.